Alright folks, welcome back to the channel one more time. We're gonna settle in here on the Tyler Robinson court case and see what the heck is going on. Here we go.
Counsel, if you could enter your appearances, please.
Your Honor, Christopher Ballard, Ryan McBride, Chad Grunander, and Lauren Hunt on behalf of the state.
Good afternoon.
Restart us here.
Don't do that.
576, State of Utah versus Tyler James Robinson. Counsel, as we're moving forward today, I want to give an overview of what we anticipate doing. And it comes down, we're addressing three issues. The first is the October 14th, 2025 audio recording of the closed hearing and the October 24th, 2025 transcript
Closed
of that hearing. The second is the state's motion to amend or clarify the publicity order, commonly known or referred to as the gag order.
That's the problem in America when you get a gag order.
Of motions to close, seal, or reclassify. And
Notice nobody can interview
the media organizations.
Luigi Mangione or this guy. I wonder why.
The first part is we'll begin by addressing the October 14th audio recording,
Dirty
the
bastards.
October 24th transcript. This portion of the hearing will be closed so that I may hear from the parties regarding which portions of the recording, the record should remain sealed. All members of the public and the press will be excused, and the hearing will not be broadcast. This is because I need to hear what should or should not be sealed or protected, and it would not benefit to have everyone listen to what should be sealed.
Well, nobody should listen.
After I've heard argument, we will invite all parties or the public and the media to come back in, and the hearing will resume transmission.
Oh, good God.
We will then take up the motion for limited intervention, followed by the state's motion to amend or clarify the publicity order. These portions, the last two portions, will be open to the public and to the press. After hearing argument on all three matters, I will take a brief recess and then return to issue my ruling today.
We'll take a recess to turn off the cameras.
So at this point, we'll go ahead and excuse the public and the media, and it is the court's order that transmission
Everyone get out.
terminated temporarily.
Yeah, that's it.
We have one request with respect to the closed hearing. May I be heard on that?
Yes, counsel.
Thank you. Richard Novak for Mr. Robinson. Mr. Robinson has some immediate family members who are present, his father, his mother, and his brother. And we would ask the court to permit them to remain in the courtroom during the closed portion of the hearing.
To the state.
I doubt it.
My only concern with that, Your Honor, is that we're going to be talking about court security measures. And I don't know that we'll have to go into a lot of detail about that, but I do have concerns about those issues being discussed in public.
Outside of the
Do you have
courtroom.
authority that supports allowing them to remain in a closed hearing?
Well, he could just tell his parents anyway.
No, I
can't he?
think it's subject to the court's discretion to decide who is and is not an appropriate member of the public. I think they have a unique relationship with Mr. Robinson, and they would certainly abide by any orders the court makes concerning
corruption.
disclosure of what is
same
discussed in
thing.
closed session. But obviously, it's up to the court.
Thank you, Mr. Novak. I'm going to rule that they will be excluded as well. It is just given the nature and the sensitivity.
Given the nature, get the fuck out.
It is appropriate to treat all parties in the public equally, though I do recognize their relationship with Mr. Robinson. Thank you for your request. All right, we will go into the closed session. Thank you.
So we are going to get booted out of court for the closure hearing. So, okay, let me just kind of fill you guys in on what's going on. So first off, we are going to hear more than just, which now we're not going to hear about the transcript, but that was kind of the original basis for us, being called into court in the first place, was to talk about the transcript from the closed hearing, what needs to be redacted and what doesn't. But like I had pointed out at the top, there's been this other stuff going on in the background, particularly, surrounding the gag order is one of the more interesting parts. And then the media asking for recognition as party interveners, giving them a certain, standing in the case to be able to participate in a limited way on issues relating to public access. So we are going to.
Well, this is kind of pointless. Just get to the end.
Um,
Okay, let's skip ahead here. What's your
prohibitions as the lawyers identify those witnesses. Doesn't really answer the what and the how and what they're required to do and so forth. And
Yeah,
so
they're not going to answer nothing. Be extremely vague. All right, where do they come back into court?
this order, this into our court.
What the hell?
Reporter from the Boston Globe was able to access some of the case information and documents. Yeah, this is what's going to happen if you don't do what you say you're going to do and seal the stuff. People are going to find it.
Duh.
This, is not unheard of. This is a thing that happens. This was not supposed to occur. The plaintiff submitted compelling reasons for the case to be sealed at this point. The reasons for the seal would be thwarted if the case information is disseminated. I don't know what that possibly is, but there is such a strong presumption against doing court in private.
Yeah, no shit.
That I got some serious questions about sealing an entire case. Sealing an entire case.
It's called
access to judicial records is part and parcel with the First Amendment right to know what the court is doing.
Yeah, back pocket.
The Supreme Court has not specifically applied that to civil cases, but multiple districts have. Multiple federal circuit courts of appeal have addressed that. As far as I know, everyone that has looked at it has extended it to civil cases because the same reasoning applies. You get to know if people are getting special justice in the court, if the processes are being corrupt.
We just want to see the evidence and hear him talk, but he ain't going to talk, I'll tell you that.
So I don't know a possible reason this is that is going to overcome that presumption. Therefore, Stephen Porter, the Boston Globe, and any other person that has access to the information obtained from the sealed court file is immediately enjoined from disclosing or distributing the information documents. Any such disclosure in violation of this order may be subject to a finding for contempt of court. And so now it's time for this judge to go back to law school, if he ever went, and read the Globe newspaper's case, because Globe newspapers was one of the very early U.S. Supreme Court cases on gag orders in court. And it's quite clear, you cannot gag the press. The press has a First Amendment right
to
report
anybody
on the information that they obtain. And if they obtain this,
and that's why they're sealing it.
Investigation, such as by finding it on your website where you didn't mean to put it up, but you did, they get to report on it. You don't get to gag the press. So this has been like black letter law for not quite a century, but well over 50 years.
This is going to continue in this
black letter law.
case.
You do not get to impose this kind of restraint on the press because you are not a freaking monarch who rules over us.
They shouldn't be allowed to do anything
whether or
at
not
all.
we get to see what you're doing. You are accountable to we the people. Now, apparently in New Hampshire, they aren't all that accountable to we the people because they're appointed judges and they get a lifetime appointment. They can only be removed by impeachment. And so, I'll give you several guesses on whether somebody who has the kinds of political connections that will get them a judicial appointment in the first place is likely to suffer political consequences.
No.
When they completely abdicate their responsibility to uphold the Constitution of
Well,
the
thanks
United
for telling
States
us
of
all the
America.
New Hampshire judges are corrupt as
To be
shit.
clear, it does not appear that he knowingly violated the order sealing the case. Nevertheless, the case is sealed and disclosure of the information or any documents obtained is strictly and unequivocally prohibited pending further order of the court. This order is effective immediately and itself is sealed. We also are not supposed to get to know that this judge is spitting on the First Amendment.
Yeah, well, I mean, knowingly or unknowingly, it doesn't matter, but he is spitting on the First Amendment. I mean, just seal everything from day one. What we're going to show on TV is him sitting there. And not a word said, and I guarantee it's going to continue. No questions, no nothing. This ain't going to be court TV in this one.
We don't get to know that either. Talk about lack of accountability. This is wild. It is to be said only to Mr. Porter, the Boston Globe, and the plaintiff. Maybe they can get that right, this time. Maybe they can get that right. So yeah, that was a pretty wild thing to see. So apparently, Mr. Porter was able to get a lawyer involved. They were able to get that. Order vacated, but this stuff, like, it's, again, I just don't know if this is new or if we're just seeing it more, or if like judicial quality is going down.
Yeah, that one.
And so the judges are getting dumber and they don't know. Dude, you are so not allowed to do that.
Dumb.
Like, this is not even a close question.
This is blacking, redacting the entire trial.
Increasingly comes up. It's mind-blowing. So yeah, it's
so that's what we got to see about 10 seconds. Hello, good morning, and turn the cameras off.
In my view, when the government doesn't think we should be able to inspect what it's doing, because that is the kind of arrogance that you expect from a tyrant. That is not the kind of openness and respect that you expect from a democratic
well, when the judge, look, man, when the judge said everyone has to get up and leave, I wouldn't have left. I would have just sat there. Frickin' arrest me. Well, you're in contempt. How? You can't redact the entire trial. You can't. It's illegal. Good luck.
Appreciate your comment.
Contempt of
very
what?
Much. Black Swan Revelations just kind of have a lot of people that are interested in this case.
Look, we're not going to come back to the court. I'm telling you. They showed
a variety of reasons who it involves.
60 seconds of the trial and then shut the cameras off and said tough shit.
Maybe aren't real familiar with the criminal process generally. I don't know what the reason is, but there is just such a remarkable lack of patience to wait for things to play out the way that the due process that our Constitution calls for has established.
And the defense ain't gonna say nothing about it unless he gets in trouble,
I'm not
talking.
really sure what to make of that.
I do.
I really don't.
It's called you're turning into Canada real fast.
To me, I've been in the system for almost 20 years.
When at the end of the trial was what did they say? The Judge Rulo in the trial. He said, yeah, they're guilty, but we don't have any punishment for them. We don't have any stated punishment for these people who called the Emergencies Act and illegally. There's no law that says what I'm supposed to do to punish them. The only thing it says is to make recommendations. That's it. So how much time did they waste in there? For a judge to look at it and what? What the hell is that? It's called Frankism. That's what this world is turning into. Frankism. I'm going to do a segment on it later. Let's go.
This happened, thousands of cases. I've walked through the system, seen the investigation, seen how they're handled, and so forth. And there's really nothing remarkable about this at all so far. There's really not. The probable cause itself, the evidence that they claim they have.
Too bad the
Nothing
camera
really
will be
remarkable about it. It's the kinds of things that I normally expect law enforcement to have and do and rely on. The conclusions that they've reached based on what they've gathered.
You're not going to hear it.
Seem to me to be pretty ordinary types of reasons and stuff like that. And I mean, I'm like the last person who would be like, "Ooh, trust the government." Trust the government. Everything will be fine. I mean, hello, it's like the first thing we tell people. Oh, the government wants to talk to you. You better shut up. You better not have anything to say. The government is not your friend. You can't trust the government. But to take that to a level of like certainty that there's something wrong here, I'm not understanding. I'm really not understanding why that is. I'm seeing a lot of like really strong opinions about the investigation when we know next to nothing about the investigation at this point. The investigation at the time of the probable cause affidavit was just the beginning. This is the bare minimum of what they needed to get started, because now that they know that it's Tyler Robinson that they're accusing, that they think committed it, now they go through a massive process of investigating Tyler Robinson. Again, looking at his digital footprint, looking at his activity, looking at where he's been, looking at the things that he's said, looking at people that he's talked to.
Well, that's fine, but look, unless you match up the bullets of the gun,
why on earth would it be expected that we would see that? We'll see that in court.
Look, all that stuff she said is cool. I understand that. But, okay, so there's a guy on the roof. Charlie gets shot. Was it him? How do we link those two things together? The only thing is a bullet. That's it. Doesn't matter if Tyler was on the roof, in Utah, in Provo, right there, standing there with a gun. Doesn't matter. He could have went up there to actually shoot him. The gun misfires. A bullet doesn't come out. It comes from somewhere else. Charlie gets killed. He runs off the roof thinking, holy crap. What do I do here? Everyone's arguing about the gun didn't come off the roof. He took the gun apart before he went off the roof. That's totally irrelevant, okay? And, in fact, in certain places, you could see the gun wrapped in a towel. Now, it doesn't look like a gun because the video is so far away and the pixelated so that you can't really see, because when you move something skinny really fast, it will disappear. Like, look. If I take this knife here, hang on. If I take this knife here, and I wave it really fast, look, it disappears. That's what happened. So the fact that people are saying he didn't have a gun, he didn't jump off the roof with a gun, doesn't matter, irrelevant. He could have been on the roof and wanted to shoot Charlie, and had a gun, and been there, and whatever, pulled the trigger. But let's say there was a misfire. The gun didn't fire. But, unbeknownst to him, there's another guy over on this roof. There's another guy over on this roof. And they all fire at the same time. If that bullet doesn't match his gun, then he's not guilty. He could have wanted to kill Charlie. This is what I'm saying. He could have went up there with a gun to kill Charlie. That doesn't prove he did it. Simple as. So, all the other stuff is just basically circumstantial. And the text to his furry, I mean, that's just weird, and we're going to have to see the evidence. We're going to have to see his phone with that message, not some printout of it, but the actual phone. I want to go to the phone, hit furry, hit contact, furry, text, chat, boom, scroll back, September 10th. See it. Not a printout, not a report. I mean, they can also have his provider give it. They can also go into the keystrokes of the phone and prove that he pressed in that message. So maybe he did say it. But that's got to be tied together. It just can't be written on a piece of paper, said by the FBI or said by somebody, some expert. It has to show his phone that said it. And that's part of the problem in these cases is they'll put the phone in a bag. Is this your phone? Yes. Okay, now we have this piece of paper over here that says this was sent from your phone. Well, they don't ask him if he sent it. They could say, is this your phone number? Yada, yada, blah, blah, blah. They can get data from the phone about his whereabouts. But unless they actually go into the keystrokes and the messages to prove that they're there in his phone, if they don't turn that phone on in court, circumstantial. Okay. Let's continue on.
We'll see that in court.
I doubt it.
I don't know.
That's why you're shaking your head, and everybody else is going to shake their
Brian,
head.
Merry Christmas. Thanks for
Okay, let's
the
fast
media
forward,
to
see if we're back
represent
in
the
court.
public interest in information as a whole, because, hey, they've got an interest in having the information so that they can report it and make money based off of that. So the relevant facts here, they're media entities engaged in the business of gathering and disseminating news, local and national organizations. They all share an interest in ensuring access to this criminal proceeding and contesting closures or restrictive classifications, including closures and classifications that have already taken place or been requested.
Yeah, that's the problem.
In the 6 weeks that this matter has been pending, the court has carefully protected press and public access rights. I tend to agree with that. Like, notwithstanding that we're sitting here waiting for court to come back because they close the door to us, we don't get to see. And it's not the first time we're having this hearing at all because of the last time when they closed the door that we didn't get to see. Nevertheless, by and large, the court has been pretty respectful of the public's right to know what's going on. As the court has recognized, this is a serious case that has garnered national attention. From the start, that attention has included media requests for access to these proceedings. This court has routinely and appropriately granted those requests, imposing conditions as needed to account for other competing interests. They have routinely granted the request to televise, and part of that is a product of the way that the rules are written in Idaho and in Utah. Utah has decided, kind of unusually, I guess, from my perspective anyway, that they're very much in favor of cameras in the courtroom. And so if there is a request for somebody to televise a court proceeding under the Idaho rules, it presumptively should be granted unless there's a real good reason why you shouldn't. And the judge has to justify that, has to articulate that in their order denying that access. Not a real common view about transparency in this day and age. You know, we still have the federal courts completely, well, I can't say completely closed off to cameras because they do have a extremely limited pilot program where they are allowing cameras in some courtrooms, but it is certainly not extensive. You have most jurisdictions where it's just discretionary. The judge can do it or not as they decide, and they frequently decide not to.
How about
Sometimes
the
they
FISA
do.
court? Should be in
So
every
just
court.
this
Court
very
in the
strong
military.
presumption in favor of having the cameras there is a little bit unusual. Unsurprisingly, both parties have attempted to chip away at these access rights almost immediately. On October 9, 2025, defendant filed a motion to appear in civilian clothes and without restraints. When it came time for the state to respond, it moved to classify its response as private. In justifying that classification, the state stated that the response includes information from the court's security director regarding specific security measures in this case. Even if this were true, and the press and public cannot, of course, verify the contents of a private filing, including whether these security measures could have been protected through redaction rather than a private classification, the state appears to have used that private filing to argue for limiting press and public access to these proceedings. In Section 5 of his reply, defendant stated that he agrees with the Utah County Sheriff that the court should limit media coverage or video or photographic coverage at the least, so defendant's physical appearance is no longer the subject of interest. I don't think that's quite how it works. I don't think that by cutting off the supply, you automatically cut off the demand. Otherwise, we wouldn't have a drug problem in the country anymore. But, perhaps their point is, well, that it's not being fed. The appetite is not being fed.
Was he wearing a suit?
Based on that reply, media interveners understand that in
Since,
addition to relaying details about security measures
this is
in its
live,
opposition
what
to
we're
the
going to do is
civilian
go
closed
back to the
motion,
court here.
the state also made broad
and
arguments
see
about
if he's in a
limiting
suit.
media coverage in this case altogether. Media
There he's
interveners,
sitting
of
right
course,
there.
oppose those arguments on their merits. Just as critically, however, I don't know for sure. Don't know nearly as much about her. She doesn't appear to of them sitting at the table, so it probably is.
Is that a tie? Dude is skinny. He's a skinny gay dude. But I can't tell if that's a tie, and I don't see a suit jacket on the chair anywhere, and he's wearing tan pants, so... Gay! Okay, let's carry on.
Be litigating whether the public doesn't get to see anything away from the public. You should not be able to hide all of that. This is another area where there's a fair amount of case law on this. Again, this is not the first case ever that's gotten public attention, that's had things come up that...
But then again, look. It's probably the first time he's actually worn regular clothes in 2 months, almost 3 months. So he's been in a jail outfit for 3 months. The first time he got to dress. So did mommy bring the attire? Or
you
what?
know, like, ooh, if it gets out, it's going to make the defendant look really bad, and so we have to, we have to come up with some kind of accommodation. This is far from the first time this has come up. It's been litigated over and over and over again for decades.
I'm tired of people saying, "Does it look bad? Does he look bad? Let's not make him look bad." The dude is top 5 in looking bad in the entire country. What are you talking about? How can you make him look any worse? He might as well just have worn the furry costume that he did the night before the shooting.
Decades. And one of the real common themes that comes up when the court wants to close a hearing, close the courtroom to the public is entitled to an opportunity to be heard on that. You don't get to just do it and spring it on the public. Now, I'm not saying that doesn't mean they don't do that anyway. We're legal realists here. We understand that what courts do doesn't always correspond with what the law says they're supposed to do.
That's why they shouldn't
But
be
if
a
they're
court.
following the rules, that we're all expected to follow, you got to give the public a right to be heard. And so it's going to be pretty hard to do that if you're concealing the fact that you're even having the conversation at all.
It's called being a Frankist.
Fortunately, the court again protected the press and public's access rights. In granting in part and denying in part defendants' civilian close motion, the court declined the invitation to enter orders limiting media coverage of this proceeding. Instead, the court made a set of practical amendments to the decorum order, including targeted restrictions regarding when defendant can be recorded or photographed. Can't show him coming in and out of the courtroom, can't show the shackles. In doing so, the court reiterated its commitment to open and fair proceedings, recognized the public's interest in and the newsworthiness of these proceedings, identified a benefit in allowing the public to observe the proceeding through electronic media coverage, and sought to promote a healthy balance between preserving the defendant's constitutional rights and the media and the public's interests in viewing the proceedings. The court should not be forced to police these critical interests alone. We were so, before that last hearing, when he announced his ruling, we knew, we're dependent on the court to be protecting the access right here, the public's interest in transparency, because media hadn't appeared at that point. None of us had an opportunity to speak up. So we knew we were dependent on the court. But the court should not be forced to police these critical interests alone. And in fact, as detailed below, the media hold a constitutional right to intervene in proceedings like this one in a limited capacity to oppose attempts to restrict public and press access. So the rest of this is their legal argument. They go through a lot of case law from all under the country. A lot of these are very famous, well-known cases, the Press Enterprise cases. There's Press Enterprise 1 and Press Enterprise 2, Waller versus Georgia, very, very famous one. Here's the Globe newspaper case. That's the one I'm talking about, that judge in New Hampshire. Dude, have you ever read Globe Enterprise? I can get you the full citation here. Right here, 1982. 1982. So not quite 50 years that's been the law, but been out there for quite some time. And so, all of these are just basically establishing
legal gobbly-gook.
Not just that the public has a right of access, but why? Why do we do that? Because if you don't let the public in, it creates an impression that you're being secret. And if it's secret, then we don't trust that it's fair. And so even if it is, people lose faith in the institution. People don't necessarily trust the outcome, because you gotta kind of treat people like they have their own minds. They can think for themselves and make up their own decisions. And so just because somebody says something is fair doesn't mean I'm going to agree with them.
We'll go into it.
If we are a society of, equal democratic participants, then each of us get to form an opinion about that for ourselves. And we get to advocate for that, and we get to elect representatives who will, see things the way that we do.
Rules for thee and not for me.
But we don't have to just take their word for it. It's not the way government works here.
Erica seems to think so.
And they make some comments here about the conflict between, information, a lot of information. Yeah, sometimes that can be prejudicial to the defendant. So there's a landmark case that is brought up in this brief. The defense brings it up all the time in theirs. But a Shepard versus Maxwell. And this case basically stands for the proposition that media interest cannot be allowed to turn the court proceeding into a complete circus. And so they describe things going on in Shepard v. Maxwell. This was a case that was like 100 years old or something like that. It's an old one, maybe not that old, but it was a long time ago. And they're talking about things like, the press is running in and out of the courtroom. They're grabbing the witnesses for interviews in the halls. They're, peeking into the files while the people are coming in and out of court. They're, just like super over the top stuff, right? It's like probably the most extreme kind of situation that you can imagine. And so it's a case where the U.S. Supreme Court said, look, this was so bad that it rose to the level of a due process violation. There was no way this guy was ever going to get a fair shake. The whole process itself was tainted by what the court allowed. And so the court has some responsibility to maintain some kind of control over the proceeding to prevent things like that from happening. So that's kind of one of the early cases that
lock it down.
Establishes like one end of the spectrum when it comes to the court's power to intervene with what the press is doing, maintain its own courtroom, its own decorum, and stuff like that, in order to safeguard.
Okay, woman, you're talking too much.
Right to a fair trial. However, just because the public is interested in a case and there's media about it,
I'm going to pause this, come back if they ever come back to court.
They're not publicity about cases and getting a fair trial.
Okay, so we are back here, folks.
Thank heavens.
Yeah.
It's about to come back because I think I might lose my voice.
And you're going to notice something here real soon.
There's no sound, but it's not me. It's not our end.
Sure.
We're going back on the record in case 251-403-576, State of Utah versus Tyler James Robinson. I note the presence of counsel that previously entered their appearances. We have come out of the closed session and concluded that business. However, the court became aware of an event that happened before.
Okay, so he's bent over here.
And my understanding.
I'm gonna go back and show you something that you're gonna notice about this case. So if we go back, you're gonna notice it is women and another woman against the men. Okay, so that's very interesting. It's very interesting to pose this as two Karens, a Karen and her protege, against a white man and a bald man. So let's go back here where the judge bends over, and we'll start her up again.
Oh boy.
And my understanding was during the open portion of this hearing earlier that there was a violation of the standing decorum order as it relates to transmission of these proceedings. I want to hear from counsel.
Been a violation already?
We'll make a
haven't even seen anything
concerning that shortly thereafter. Ms. Visser.
Thank you, Your Honor. I'm referring specifically to Rule of Judicial Administration 4-401.01. This gives the court discretion to terminate or suspend electronic media coverage at any time without prior notice, if the judge makes particular findings and that the specific circumstances warrant it. It is our position, the defense position, that there has been a violation of the decorum order. It is our understanding that those live streaming this signed and declared that they would follow the decorum order, and they violated it. So we are requesting a sanction. We believe these court's orders are binding and they need to be respected. We also believe that it threatens my client's right to a fair trial. It's the whole reason we filed a motion in the first place to remove his shackles. It's our understanding that his shackles are visible. It is also our understanding that potentially some audio.
Oh, Karen arguments. Here we go.
We are definitely taking more measures on our own to ensure that that does not happen again. But there has also been some filming of computers and materials at counsel's desk. That's entirely inappropriate. And I think everybody in this room will agree that's entirely inappropriate. So we are asking for some remedial measures here. We're asking for it to terminate for today, and we can proceed after that.
Thank you, Ms. Visser. To the state.
Your Honor, the state, as stated earlier, we believe that the court's order was very clear. And if there has been a violation of that order, then we agree that there needs to be some measure taken. We'll leave it to the court to decide the appropriate response to that violation. But we agree that any violation of the court's order needs to be addressed.
Thank you, Mr. Ballard. To the press, attorneys for the press.
What the heck?
Your
I think
Honor,
we need
Jeff
some
Hunt,
evidence.
Media interveners. This is the first time that we've heard about the violation. We've not had an opportunity to look at the video or investigate the audio or look at the capture of the computers, but filming of
Why is there three sides to this story?
inadvertent filming of the shackles. I did talk to the pool photographer. My understanding is that there was a zoom out shot that did inadvertently show the shackles. That was improper.
Oh, who cares?
Inadvertent, and we apologize for that. They've taken measures to make sure that the pool video that is disseminated to the rest of the pool does not contain any capture of the defendant in the shackles. We can't do anything about the live stream, of course, but we can control what the rest of the video is that we capture and disseminate. So that is being done. The audio for counsel, my understanding is the only audio that they picked up was from counsel's microphones. I don't have any further information about that and whether that's a violation.
Why? What the? Why are they trying to block people from live streaming? Like, this is absolute retardation.
Filming of the computers is not a violation of the decorum order. If the capture can show the document that counsel is looking at, then that is a potential violation. So I just don't know how much detail the shot is that is of concern to the court. But I'll just
Well, it must be in 10,000K.
We reiterated as soon as I heard this from Mr. Ballard with the pool representatives that this is very important to follow to the letter of the court's EMC order.
Wow.
They understand their obligations. They take that very seriously. They're not
Do they?
perfect. Mistakes happen. We're trying to correct as much as we can on that. But we think termination is not an appropriate remedy. An admonishment from this court, a reminder that they need to follow to the letter the court's EMC order is appropriate. That's the message that counsel has delivered
Oh,
to
this is
the media
like woman
representatives
arguing.
and the
Come
pool
on, man.
operatives, and we think that is the appropriate remedy.
Thank you. Thank you.
I just want to make it clear, we're still receiving messages that shackles can be seen on the live stream.
Holy Christ. Shut up, Karen.
Started, so it's still a problem.
Thank you. I appreciate all parties weighing in on this important matter. And I find that there was a violation of the standing decorum order that was in effect as of October 30th, 2025, based off what's been proffered.
I think she's full of crap,
The
too.
EMC order signed by the court. As previously stated by Ms. Visser, the court does have discretion in determining whether to terminate the broadcast of these proceedings, and
That's all she's trying to
specific
do.
circumstances warrant such action that the court would need to make findings in order to do so.
Do that tomorrow.
I find that excluding the cameras from the courtroom would be disproportionate for this hearing.
Yeah,
I
good.
find that given
Good.
They beat you to it. You're too
clear,
slow, woman.
First, that the transmission cannot begin until
You cannot
the court is in
Karenify this
session
court.
and must end.
We've already furrified it.
Right, as the court ends the session, and cannot be filmed before or after. The filming of, as previously stated in the decorum order and EMC, must be followed to the letter. The sanction for today is that this camera will be relocated away from defense table to to where the bailiff is, Mr.
How about behind your head?
Where Jeff is
Put the
standing.
camera right back here.
I want to immediately address any possible transmission of shackles, as previously stated by counsel, and remove the possibility of capture of screens of the computers at defense counsel's table as well. In addition, if there's further violations of the standing decorum order, this court does have the right and will exercise termination of broadcast of these proceedings. And I simply want to put all parties on notice, to the press, to all parties, that this court takes this very seriously. While the court believes in openness and transparency, it needs to be balanced with the constitutional rights of all parties in this case.
Oh boy. What those cameras, where's cameras in the Constitution, okay?
And to the place
Another recess.
Number one.
And then we will resume these court proceedings. I am anticipating this to take perhaps 5 minutes. All right, and then we'll come back on the record and handle the remaining of this hearing.
Oh, they're going to block out
Appreciate the
another 5
patience of
minutes. Are
parties
you serious?
As we move forward, we are trying to do the best.
Oh my
Sorry,
God,
we
you
cut it off again
bastards.
already. Oh, well, you know, seen this story before, haven't we? We were just talking about how over in Coburger, media just couldn't follow the rules. They're crystal clear. Just couldn't do it. Went and got the cameras yoinked for all of us.
Gee, I wonder if they're going to
Fortunately,
do
they
that
had
on
backup
purpose.
that they let us watch in that particular case. But I don't blame. I really don't. I don't blame the defense for being annoyed and frustrated with that.
Oh, 'cause
I
you're a
don't
woman,
blame
too.
the court
Zip it.
for
Okay, I'm coming back if they... Okay, I guess we're back. Let's settle in. This thing's only been going on for freaking ever. I mean, this is totally ridiculous. Okay, let's hit it.
And then we can go from there. Mr. Ballard.
Thank you, Your Honor. With respect to this motion, I think as we've expressed in the past, everyone in this room shares the same goal, and that is to ensure that there's a fair trial that happens in this case. And we recognize that the court's pretrial publicity order is intended to further that goal. And again, as I've stated before, the state plans to try this case once. The state is also committed to complying with its ethical duties with respect to pretrial publicity. We have complied with those duties. We will continue to comply with those duties. The issue we bring before the court here is that there's one portion of the pretrial publicity order that can be interpreted to
I'm
reach
blocking the
beyond
dude
those
out. Hang
ethical
on.
requirements.
Hang on. Boy. Okay, here we go. Let's try this again.
And have the effect of being what would be an unlawful order, an unlawful prior restraint on speech. And our goal, therefore, is to get an order that's clear, that's lawful, and that the state has the ability to comply with. And The issue with the order that the state has is the use of the term witnesses in the order. We believe that term's vague and ambiguous. Does it mean anyone with relevant information about this case? Does it just mean those people that are going to be subpoenaed to testify in this case? Or is it
Very good
limited
question.
to just the prosecution team? And I think as we've expressed in our filings, we believe that the court intended that that term just be limited to the prosecution team, because that is the way that Rule 3.8 reads. Rule 3.8
Well, they can introduce their own witnesses.
of the rules of professional conduct that deals specifically with requirements for prosecutors
What?
talks about investigators,
No,
law
it's
enforcement
papers.
personnel, employees,
Get that
or
freaking
other
camera
persons
back.
assisting or associated with the prosecutor. So in other words, the prosecution team. And there's no rule or case law or statute that expands the prosecution's duties beyond that group, the prosecution team. So with respect to clarity, we're seeking clarity as to what exactly does the court mean by witnesses. And we think the court just means the
Everybody in
prosecution
Utah
team,
and everybody on the
because
internet
if
that saw it.
that term stretches beyond just the prosecution team, then the order is written, we don't believe is a valid and lawful order, because
So you're trying
it
to
would result in a prior
possibly...
restraint on certain speech.
Wait a minute. They're trying to possibly limit the witnesses to not possibly include the actual killer, from what I based on earlier. But I guess they would be a witness in reality, but he's trying, like, okay, say for example, let me think here. Okay, so possibly if there was like two or more shooters, like whatever. So what they're trying to do is, if you shot Charlie and got away with it and ran away, and we don't call you up to the stand, then you're not a witness, even though you were there shooting him at the time. That's lovely. Jeez. Jesus. Get a grip, people.
And at the very least would have a chilling effect on that speech. If the prosecution agrees that we have an ethical duty to take reasonable
Prosecute him, not anybody
to make
else.
sure that those who are identified with the prosecution team are alerted to the requirements of the court's order, and to make sure that they do not make a statement that the prosecutors themselves would not be able to make.
Okay, so what he's saying is only our witnesses are witnesses. The defense witnesses are not witnesses. So if the defense decides to hire a private investigator to actually find the alleged killer, and they find him, then he's not a witness that they can bring up to the stand. What the hell's going on here?
Public statement. But if the order extends beyond that, then we have concerns, because a prior restraint is an order that forbids certain communications in advance of the time that they are to occur. And as the Court of Appeals has recognized, the Utah Court of Appeals has recognized in State versus LM. And widespread publicity in a case does not itself justify a prior restraint.
Correct.
As the United States Supreme Court has recognized in Nebraska Press Association, there's no justification for a prior restraint unless it's clear that the further publicity, unchecked, would so distort the views of potential jurors that you couldn't find 12 jurors who could be fair and impartial.
Okay, first of all, look, man. It's going to be bloody impossible to find 12 jurors of his peers in Utah. How many furries are there in Utah? I mean, even when they came over to the house, how many sons of law enforcement in love with furries are there in Utah? That's a jury of his peers. It's not some Mexican guy and some guy from Greece and some lady from China. That's not his peers, you understand? So this is just washing out the whole bloody thing. I mean, I hope the judge sticks to the rules and says if somebody else comes forward and confesses to the killing, then guess what? This guy's off the hook. Now, I'm not saying he's guilty or not guilty, but I think he did plead not guilty. Because they wouldn't be doing this at all if he didn't. But anyway, if somebody else comes forward and confesses, then guess what? They're excluded from being a witness because he's telling the judge right now, the witnesses are my witnesses, not their witnesses, and not somebody else outside of the courtroom once we get the jury in here. Once that first jury person walks in, we're done with witnesses. Even if somebody confesses or we find another suspect. Which, you better have some private investigators if you're looking for another one, but I haven't heard of any yet. There might be some on the side, but oh well.
That's the high standard
Let's carry on.
that applies in this case. And so in order to apply a prior restraint to persons beyond the prosecution team, the court would need to engage in a very detailed and demanding analysis. The court would have to make a factual finding of necessity, that the speech that would be restrained poses a risk of material prejudice to the ongoing judicial proceedings. The court would need to make findings that there are no less restrictive measures and that the prohibitions are likely to prevent the potential prejudice, and that whatever prohibitions this court decides on are very narrowly tailored. And as the state has explained, the Spencer versus State case from the Arkansas Supreme Court that just issued earlier this year is very helpful, I think, on this issue in explaining the analysis that applies to various different people that might be associated with a criminal case. You have attorneys, that category of trial participants. Certainly the court has the highest degree of ability to be able to restrain the speech of attorneys. And in fact, as I've expressed, the ethical rules require that. But when it comes to trial participants, like witnesses, the standards are more demanding as far as restricting the speech of trial participants. And as the Spencer case pointed out, non-attorney trial participants, the court can impose a restraint on their speech only to the extent that the court first finds that any speech by those non-attorney trial participants poses a serious and imminent threat of material prejudice to the ongoing proceeding. And I think the court also needs to note that there are several people associated with this case who have very significant interests in exercising their First Amendment rights in talking about how this case has affected them. And of
We're
course,
talking about Erica.
Can't say that one person's First Amendment right is more important than another person's, but there are certainly some people here who have a larger, some people involved who have a larger, or greater interest.
This guy can't talk. Why is he a lawyer?
And so I think the court needs to take that into consideration if this order is meant to apply beyond just the prosecution team. And then finally, as far as making the order, so we need a clear order, we need a lawful order, and then we need an order that the state can actually comply with. And the state recognizes that there are serious sanctions that this court can impose for violations of a court order, as we've just seen. And so we want to avoid these. We want to avoid litigation over whether there's been a violation of the order. And as it stands right now, we don't believe that there will be any issues if the court.
What the? Did you hear what you said? I gotta back that up a second.
order. So we need a clear order, we need a lawful order, and then we need an order that the state can actually comply with. And the state recognizes that there are serious sanctions that this court can impose for violations of a court order, as we've just seen. And so we want to avoid these. We want to avoid litigation over whether there's...
We want to avoid litigation. What the? Okay, look, man. Look. He just said, we want to avoid litigation here. This is not about the law. This is about running this boy up the flagpole. We don't... Did you hear what he just said? We have legal orders, we have to go by the law, we have to do this, and we want to avoid litigation. Litigation is what this is all about. What are you talking about? Lord thundering, man.
Been a violation of the order. And as it stands right now, we don't believe that there will be any issues if the court limits the term witnesses to just the prosecution team. We can comply with that order. It gets more difficult for the state if the term witnesses then applies even broader at this stage of the litigation for the state to be able to
So no
comply with
private
that order.
No privately hired
court clarifies what witnesses mean.
private investigators. Just hired by these two Karens that we put in here without asking.
Thank you,
Okay, thank
Mr.
you.
Ballard.
Judge is like, you just wasted my time, dumbass.
I'm going to try to be brief because our views on the propriety of the court's order were set forth in a publicly filed document, which, of course, the court has reviewed. And the first thing that I want to say is that the order that the court issued is not a prior restraint on any member of the public, and it's certainly not, I think as the state's motion suggested, some sort of a prior restraint on the press. This has nothing to do with the press. The order, as we noted in our paper,
Get with it, man. Speak.
is directed at the conduct of and the court's expectations for counsel. So even if under that...
Oh, you didn't do this in private? God, you had the camera off for 10
somebody
minutes.
who we could all agree is a witness within the court's definition of that, made public statements which implicated Mr. Robinson's fair trial rights, the potential sanction is on the party who had a duty to make a reasonable effort to notify witnesses that they should not be doing so. If I represented a witness who was accused of saying too much publicly, the first thing that I would tell this court is the order isn't directed at the witness. The order is directed at the counsel for the parties. There may in the future be some theoretical situation where the court issues orders that...
And we need to squash that right now.
Control the statements or conduct of specific people, but this, or other than counsel, but this order is directed at counsel. And we have no, meaning Mr. Robinson's defense counsel, have no problem complying with the order. And we also think that we understand what a witness is when the court uses that term. So it is our view that the court's order is not overbroad. It's not.
This guy is vague as vague can be to not give away the game.
The state or the state's attorneys in some untenable position. And I think it's a little bit, it's a little too simple to say witnesses are either everybody under the sun or people who are under subpoena at the last second. Because counsel have
Is this Ezra's brother-in-law?
to figure out along the way who the potential witnesses are and to notify those people. And yes, down the road, maybe there's going to be an issue, and maybe an attorney on either side of litigation is going to have to explain to the court when a particular person did or did not become a potential witness in the eyes of that party.
So helping your
That
argument.
doesn't make it impossible for the state to comply with the order. It just means that the state needs to be thinking along the way about who its witnesses may be. And that's why in our papers, we refer to it as a,
Couldn't do this, well, the camera's
potential
off.
lay witness, because we believe that the court intended it to go beyond members of the prosecution team, which are law enforcement officers, retained experts, retained consultants.
Yeah, exactly.
And we don't believe that that creates an enforcement problem. We don't think it creates a compliance problem. We noted in our papers, and I'll emphasize here again, that the court's order actually places responsibilities on defense counsel that the rules don't. The rules have special guidelines for
What the
prosecution,
hell?
and the court has expanded that to include the defense, and we don't have a problem with that. I also think that the standard that the state is suggesting for when a potential lay witness, as we've defined that in our papers, may make public statements that violate the court's order. The best standard is actually the one that we believe.
Oh, this judge has to cut this guy off, man. Otherwise, this is a sham. They're trying to exclude possible future witnesses while saying we're not trying to exclude possible future witnesses. What happens if on day 1, minute 1, one of your potential jurors just goes and blows the horn to the papers immediately? Are you gonna rule a mistrial, start over at minute 1, and do all this crap again? Come on, man.
The court should look to, which is the standard
Cut him off.
set by the 10th Circuit, because as the state points out, it may be that there isn't any Utah law on this issue. So it seems to me that the closest source of authority on this constitutional question.
This woman was talking about the way this judge seems soothing. Okay, that's a woman term. Look, this isn't No Nut November no more, Judge. Jump on this guy and say, look, I know what you mean. Let's get on with it.
Is going to be the 10th Circuit, and that's the case United States versus Tijerina, and I'll spell it. It's Tijerina, 412 Fed Second 661.
Write that down, lady.
69, where the court says that the constitutional balance between the First Amendment rights of a non-attorney participant and the defendant's right to a fair trial are properly balanced where extrajudicial statements present a reasonable likelihood of prejudicing a fair trial. That is a more protective standard than that which appears in Rule 3.6.
Is this why you put all the rules on this trial?
Which should be applied here. That's part of, as we've told the court before, a motion that we will bring because we actually.
Well, look, man, I think they just personally put on these rules so that they can actually kick the cameras out and do it behind closed doors, so then they don't have to do all this vagary crap.
Actually think that while the court's order is wholly appropriate, it's not vague, it's not overbroad, it's not a prior restraint, it doesn't create a lack of clarity for the state. We would like it to be a little bit broader in other areas.
Mm-hmm.
We'd like it to be vague.
The standard to be applied and the definition of what is the prosecution team, but that's not germane to here. So we think that while we understand the state's concern, we think that their motion should be denied. I think at the last hearing, the court actually clarified verbally from the bench.
Are you not the
by a
state?
witness, and I think that's pretty close to what we described in our papers as a potential lay witness. So I feel like if I say anything more, I'm going to be reiterating again what's already in our papers.
No.
If I've muddled it,
Is this
I'm sure the
his,
court will tell me and I'll clarify it. I hope I haven't.
Thank you, Mr. Novak.
Okay, thank you.
Is this his lawyer or?
All right, and we'll turn to the last matter. Anything further, counsel?
Maybe it is. It is.
Yes, thank you, Your
But he
Honor.
doesn't have the
I do
all-woman
want to
team.
point
He
out
has-
that
he has
the
an Ezra
court's
on there,
order,
too.
as it's written, does impose limitations on speech. And the issue here is whose speech? Is it just the prosecution team members, or does it extend beyond that?
Ezra
And
Small.
limitations on speech are a prior restraint. The court's order says that, if you look at page 2 of the order, it specifically talks about lawyers, that lawyers cannot make a statement that would violate Rule 3.6 and need to inform witnesses that they cannot make similar statements, and then requires the parties to inform lawyers, excuse me, I'll just read it. Lawyers participating in the investigation or litigation of this case shall inform all witnesses, and then the list that I read, about the prohibitions contained in this order. So the order is prohibiting speech. And because if it extends beyond the prosecution team, it needs to have the findings that are required for that kind of prohibition on speech. That's what we're asking the court to do.
Thank you, Mr.
Oh,
Thank you.
boy.
All right.
Okay, Judge.
Let's turn to the final matter before this court, the motion for limited intervention and request for notice of motions to close, seal, or reclassify. And I'll hear from the parties on that.
Limited interventions. Here we go. No outside private investigators. We've shut her
Thank you,
down.
Your
We
Honor.
haven't offered
David
him a
Ryman,
private
representing the
lawyer.
news media. Mr. Judd and I represent different groups of clients, so I'm going to invite him if I miss anything to weigh in after I'm done. But my intent, the issues are basically the same, so my intent is to address them for all of the interveners at once, and I'll be very brief. We have only ever sought, in this case, limited party status. That is what we do in every high-profile case that involves these type of closure issues. We are not seeking to be parties for all purposes. We are just seeking to be parties for the purpose of showing up and being heard, which we unquestionably have a right to do. We unquestionably have standing. That is settled law in Utah. And the last filing at least, that we got from Mr. Robinson's team that just came in, I don't know if it was a couple days ago, basically gets there at the end where it says, look, if you're going to grant them intervener status, it should just be limited. That's all we've ever sought. And so the question that was raised in the only case that they cite, this FL case from the Utah Supreme Court, that addressed whether we wanted to allow full party status under Rule 24 of the civil procedure rules in a criminal case, they said we don't need to do that. The woman in that case just needed limited party status. And so in a way, we're not really, the state really hasn't disagreed with this either, but we're not really disagreeing with Mr. Robinson's team. We have explained in our papers that we've cited the court to extensive authority saying that this is the procedure to use. It's the most efficient procedure to use. Otherwise, I don't know what exactly the suggestion is for Mr. Robinson's team that we're supposed to do from here on out, but it kind of sounds like just this sort of ad hoc show up anytime you happen to see something on the public docket that might affect the public's rights, and that's just not the orderly way that this typically happens.
Shite.
The other thing, as I've mentioned in our papers, that it does is it allows.
Hey, look, man, if you're not paying attention, you don't get to be there, press.
Appeal of a closure issue without having to rely on the court's extraordinary writ jurisdiction. And that was what they had to do in either Kearns Tribune or Bullock, where the media was not granted party status. And it is the situation that happened in FL, where they had to review her claim regarding records under extraordinary writ jurisdiction rather than invoking their appellate jurisdiction because she was improperly denied limited party status. So all of that authority supports the process that we are requesting in this case. We think it's the most orderly way to do it. And I'll end just by saying, you know, there's been some discussion, and especially from Mr. Robinson's attorneys, about what rule it is that you need to do this under, whether Rule 24 applies. They seem to suggest that it doesn't. I will just point the court to two different rules that give you the authority to do what we're requesting, aside from Rule 24. Rule 24 is in the civil procedure rules, but Rule 81, and particularly subsection F of that rule, says that the rules of civil procedure govern in criminal proceedings where they don't conflict with a rule of criminal procedure. That's the case with Rule 24. That's why courts in criminal cases have relied on that rule. The other one is Rule 31, and that's in the criminal procedure rules. And that gives this court the discretion, if it's not inconsistent with the rules, to fashion remedies and to deal with civil procedure, not civil procedure, but rather just procedural matters. And so that is essentially what happened in the FL case, which is that, you know, whether you do it under Rule 24, whether you do it as a judicially created, you know, remedy, it doesn't matter. It's the same, it gets to the same place, which is just that we are interveners for the very limited purposes that we've set forth in our order. We're not going to be here at every hearing arguing, you know, we didn't take a position on the gag order motion that you just heard. We are only planning to appear and argue so that the court has the benefit of someone who's representing the interests against closure. Because as you know, and this is sort of why we're here today, a lot of time this just happens by stipulation, because these, you know, the state and Mr. Robinson's lawyers, they may not want to fight over a particular issue. And so it really is a situation where no one really represents that interest. And the purpose of this whole process is to give the court the benefit of the briefing that we've submitted and the benefit of arguments to represent the public's right to attend these proceedings. So unless the court has any questions, that's all I have.
Thank you.
Thank you.
To the state, Mr. Bellick.
Are they going to come up every time? Just say I'm good.
As the state briefed in briefing on a prior motion, I think it's clear that parties have outside entities have the ability to intervene in a case as a limited purpose party when there's a statute, a rule, or case law that authorizes them to take specific action in a proceeding.
Yeah.
And there's well-established case law that allows the media to intervene, to be able to appear and be heard on matters of public access to court proceedings.
You don't want that.
Documents. And Rule 4-202.04 of the Rules of Judicial Administration also make it clear that the media can appear and do just exactly what they've done in the closed session that we held earlier. So it doesn't make them a capital P party to the case. It makes them a limited purpose party, and they certainly have the right to be able to do that. Thank you.
Thank you, Mr. Bellick. Ms. Visser.
No objection. Sit down. We don't want to hear you.
Thank you, Your Honor. So I just want to clarify the issue really, if we boil it down, is
you're going to lie.
23 media entities have met their burden to be a limited purpose party in this case.
Is that it?
Another part of that is what that means. And really that is what we are primarily concerned with.
Oh, good God. There's 23 press outlets. We have to deal with all of them and call them all and give them the schedule and everything. Well, that's up to the state anyway. You're the defense lawyer. You don't do that, dick face. So what are you arguing about? Your record? In case somebody finds something hiding behind your defense lawyer's record? That's the only thing I can think of. Let's see what she comes up with.
What does that mean? What does that enable them to do? What jurisdiction is this court exercising over them as a result of them being a limited purpose party? Because I do believe that is another aspect of asking to intervene in a case. I do think that
Suck your
Rule
teeth.
24 does not apply here. I think that's what we learned from the Supreme Court.
Who
I
cares?
don't want individuals using Rule 24 of the Rules of Civil Procedure because it's too expansive. It's about broad.
Weren't these lawyers appointed to him? Or did he hire lawyers? We need to find this out.
Entry into a case for many purposes. In the instances where our courts have allowed intervention into civil cases, and I wanna
Not
be very
intervention.
clear
It's
here,
not a civil case. So what the hell are you yapping about?
law is in the civil arena. There are very few instances where we're dealing with this in a criminal case on appeal. So
I wonder why.
we're a little bit in the dark.
Jurisdiction
And
problem?
we're asking this court to kind of wade through and make a decision that potentially hasn't been made before. But I would ask the court to be very clear, no matter what it does, on what the media can and can't do in this case. And it
What the hell
sounds
are
to
you
me like the
talking about?
media has somewhat conceded that their role in this case is under Rule 4-202.04. And their role is to have a voice regarding closure, which has already happened today and will surely happen again. We have no objection to that. And to be clear, we're not objecting to the court's order about notice. We will provide notice.
You don't have
We will
to.
follow the court's order. We have no problem with it. But we do want this court to make the procedure very crystal clear. We want timeframes. We want orders saying this is when you need to respond so that we don't end up with filings like we did this week, very shortly before the hearing, that we have to rush to respond to. We're all attorneys. We all know that these things happen from time to time. And we're not unreasonable
haven't
folks.
cemented this
If
thing
they
down
reach
yet?
out to us, we will grant reasonable requests for extension, just so everyone is aware. But there was no communication. So
Oh my good God, we've been doing this lawyer thing for 200,000 million years, but we still haven't got to a schedule on when to tell the people when to show up. Ah, boy, what the hell is wrong with these people?
I want it very, very clear what they can and can't do. It's less about semantics. This isn't about semantics. It's about substance. What are they allowed to do? If this court wants to call them a limited purpose party, that has to be, well, it's so you can exercise your rights under 4-202.04. And in doing so, this is what you need to do. That's what we're asking the court to do.
You haven't done this already?
And I also have some practical concerns that maybe need to be addressed with the court's clerk. For example, are we adding all 23 media entities to the court docket? Will they have access to all of the filings? I have had instances in the past where, unfortunately, parties have been added to a case and still receive documents that are intended to be private or non-public. I'm very concerned about that. So
Oh,
I think
boy.
it would be appropriate if they are going to be added to the docket that it be reasonable, perhaps just the two entities that are requesting, the two conglomerate entities that are requesting, and that there be an order from the court saying if they receive.
Well, she's arguing for a limited hangout. In certain parts of the trial, we want a limited hangout. Even though the press wants to be notified beforehand and notified, they still haven't come up with a schedule for that. And now she's trying to make it a limited hangout. Like, if we want to make this thing private or this thing private, because I'm not hired by this. We need more details. This is stupid. Come on.
Something that they shouldn't have, they notify us in the court immediately and they delete it. They don't review it. At a minimum, I think that's necessary. But I also think it would be reasonable for this court to not to put them on the docket for that very same reason.
Oh boy.
So we don't think that they should have permanent status in this case. We don't dispute that they are going to be here. They're already here, as we well know,
I can't believe that
but we
was.
do think how that happens is important, and that this court should exercise its authority to make very clear what everyone's roles are here. And as I believe they put in their briefing, that they are neutral observers.
Your role is to not
Neutral
be a
observers.
Karen.
We don't want the chaos that is out in the media.
But you're going to come out and Karenify
courtroom.
this.
So whatever this court can do to prevent that is what we're asking.
Yeah.
Well, just come to my
Does the court
channel.
have any questions for me?
No, thank you.
Thank you.
I just wanted to yap because I'm a woman. Oh, God, here he comes back
Very
again.
briefly,
De-Karenify.
I'm not sure what neutral observer is supposed to mean. We have interests in the case. We are here to advocate for openness and against closure. And so I don't think that's what counsel meant to imply, but that's the whole reason we're here. Is that no one else represents our interests. That is straight down the middle of what the intervention rule requires. Just a couple clarifications. Counsel said we haven't cited any criminal cases where this has been allowed. That's not true. We cited the court to 8 different cases, all criminal cases in the state of Utah, where this is a procedure that judges routinely follow, including judges in this building. Counsel said that our role is strictly limited to advocating for what is under Rule 4202.04. I don't think she meant this, but as the court probably knows, that just deals with court records. We're also entitled under governing constitutional case law to advocate against the closure of proceedings.
Yeah.
And, that rule does not technically apply to proceedings. It just applies to records. So just to be clear, but I think we have been clear, and this is all, I mean, there wasn't a whole lot of daylight between what counsel was just suggesting our role should be and what we've asked for. You know,
it should have been done a week ago.
If they file a motion that seeks to prevent, that wants to classify something as non-public, like they did last night with the motion to disqualify, they were able to at least provide that to us. It's not very hard to send an email. That's
and
all
he should have been able to report on it.
Notice.
Well,
and then we have the right to be heard
huh?
on those issues. And so I didn't really hear from counsel any reason.
Oh, he let the cat out of the bag.
Limited party status in this case, other than just some sort of, you know, confusion on their part as to what that would actually look like.
That is a good one,
I don't know
buddy.
how the clerk deals with parties on the docket. I assume you guys can sort that out. Typically, when we intervene on behalf of the news media in cases, they are listed because they are limited purpose parties. But the court can, you know, if it doesn't want to hear from us on a particular issue, it can certainly say that. I mean, we don't have any interest in weighing in on aspects of the case that don't have anything to do with the public's right to know. And so I didn't really hear an argument against what
why
it is
would
that
you?
that we are asking to do. Just one last point on, well, 2 things. One is that counsel's chastising us for filing something late. I mean, this was a stipulated motion that got us here today. We weren't asked to weigh in on it. It was submitted to your honor with an order, you know, which they just assumed you would sign because it was stipulated. It was only because this court said, no, I'm not going to do that. I want to actually hear from the parties that we weighed in. So this was not your typical like deadline where we were invited to weigh in and just didn't. Last thing.
So they're already screwing with the case. He's put that cat out of the bag. He said they tried to disqualify some part of the case, so that cat's out of the bag. Just put the whole damn thing on TV. Why do we not know who his lawyers are? Or if they're hired or provided? Why was nobody allowed to try to be his lawyers? Or at least put into a lottery? Possibly. Why is things being quashed or disqualified? Maybe not quashed, I'm not sure of the legal term. But this guy's just going to let the cat out of the bag anyway. It's hilarious. Okay. Carry on, buddy.
Is in terms of docket access, you know, Mr. Hunt and Mr. Judd and I are all officers of the court. If the court says you can have access to things that the parties are seeking to classify as non-public, but you can't share them with your clients until further notice from the court, that's fine. some judges do handle it that way. Sometimes we just, if they don't concern closure, sometimes we don't weigh in at all. But when they file things that they say we need to file this under seal and we're not allowed to see it, then the briefing for you is not super helpful. And so typically the way this happens is we are allowed attorney's eyes only access to documents just like the state.
You notice how this is all legal gobbly-gook in order to hide stuff from the public. And this guy's up there saying, look, man, I know you're legal gobbly-gook. I know it. I'm a lawyer. Dum-dum. So let's not go down the gobbly-gook road, because I know how you people are.
State and the defendants would be. Their counsel can see things that are non-public, and we don't share them with our clients.
This guy's got a headache already.
Otherwise. And typically, if the court decides, no, this really doesn't need to be filed under seal, then we can provide it to our clients at that time. But this idea that our clients are somehow going to get access to things that are non-public, that's just not the way this typically works. If they're not public on the docket, if they're public on the docket, anyone can get them. And if they're not public on the docket, then our clients can't get them. And if there's a procedure where we can see them so that we can give the court the benefit of briefing substantively as to what it is, then we keep them attorney's eyes only until the court orders otherwise. So that's just typically the way this works. So thank you.
I'm sure the judge knows that already, but he's just letting the cat out of the bag to the public. Here comes Karen again.
More, huh?
Here comes Karen.
Your Honor, I'm not going to belabor what's already in the briefing. I do think it's concerning to just cite to a bunch of trial court cases without providing any pleadings or context for what occurred in those cases. I can't argue against what happened in other cases. This is our case. Our case is different. This court has already acknowledged it. There are many interests. We have concerns about leaks, information getting out that shouldn't be out.
Well, tough.
I think those are valid. And our concern is access. I'm not impugning the integrity of these gentlemen. I'm sure they would act as officers of the court. But the more this court controls the information that ultimately—
Why are you asking for that?
Private, the more able we are to identify if there are leaks, if there's information that's getting out that shouldn't be, and who did it.
Oh, Jesus Christ.
So we are objecting to providing the media our pleadings in advance, even just to their counsel. We don't think that's appropriate. I don't see any authority.
Well, then don't.
For that. We're asking the court not to consider that. And we're concerned about opening the door to multiple other entities just filing in on this case, getting involved in the proceedings. We don't know exactly what media means either. So our position is and remains, they can file what this court has authorized to file in the manner this court authorizes to file.
They're not going
to. The manner this court.
They're just going to be vague.
We understand they're entitled to closure hearings, and I did make a mistake. We agree that they have standing to object to closure as well. So they should be able to file those things, but we do not agree that that requires.
Why has this not happened behind closed doors? All this gobbledygook.
Have any questions?
No, thank you.
Thank you.
No, I don't have questions. Piss off, Karen.
I appreciate the argument from all parties throughout this day.
We haven't got into the case yet.
And the quality of the arguments, as well as the civility that is.
Oh, God, pussy. You should have sat them down a long time ago.
Appreciate counsel's demeanor and their arguments today. I previously stated when we began that I would be issuing rulings on the first issue. And when I began, I initially said October 14th. It's actually the October 24th audio recording of the closed hearing, as well as the October 24th transcript of that hearing. And so I wanted to create, just make that small correction. But given the in-depth and necessary arguments made in the closed hearing, I wish to take the time to issue a ruling that will say what will be disclosed and what will be kept private, because this court has a duty to do so. And I would rather do it right and take more time than to be rash and miss the mark.
All right, so get
I
on
need
to the
be
next thing
narrow
and
in my
decide tomorrow.
approach, and it is an important issue, and so I plan to do that. In regards to the motion for limited intervention and request for notice of motions to close, seal, or reclassify, I also wish to craft my order in such a way that is concise and addresses all the issues, the important issues brought up by all parties. And so I will be issuing that ruling at the same time. And so I will be issuing the ruling in regards to the state's motion to clarify court's pretrial and trial publicity order, and I am prepared to do so. Before I do that, what I want to do is, and counsel is being caught off guard because they were anticipating a ruling today, but what the court is intending to do is, and proposing to the parties, is issuing an oral ruling on WebEx that all parties can attend to. The reason why is I don't want to take a lot of time. These are important issues. I don't want to wait until January 16th. And I want to talk about potential dates. I don't imagine it will take longer than 20 minutes for this court to issue ruling. And I want to get the parties' input in regards to their thoughts of the court issuing an oral ruling on WebEx. And so I'll open it up to the parties.
We don't have any objection to that, Your Honor.
Thank you.
We have no objection to that, Your Honor.
Yeah, same.
All right. Well, next comes the trickier part when you have a room full of attorneys trying to find a date that we're all available.
Off to the races.
Our staff, what dates do we have available for a 30-minute block before the end of the year?
30 minutes.
We do have December 29th at 10 o'clock.
Yeah, boy.
How does that appear? How does that date work for council?
It
That was
does.
10 a.m. on the 29th.
Yes.
Your Honor, that works for Mr. Robinson. Thank you.
Same for us.
All right. And to defense, in regards to Mr. Robinson, what is your position on, if it is on WebEx, he would be appearing by WebEx, or is there different thoughts?
We don't know.
Noticeably not asking him what he thinks about that.
Your Honor, if we
course
could
not.
just have audio only for Mr. Robinson to appear.
Audio
since he
only?
will not be present. I would rather not have him in the courtroom without counsel present.
Good boy.
Thank you. I appreciate that. So we will set the court's ruling on those two issues for December 29th at 10 a.m. And note that it will be audio only for Mr. Robinson per defense's request. And to the last issue is, well, before I issue my ruling, I anticipate, and counsel, are we still on the same page in regards to our January 16th hearing? Are we planning for that?
Your Honor, we are. We believe that most likely what we would anticipate doing is on January 16th, arguing our motion to disqualify the county attorney's office, which was just filed. That should give them enough time to respond to that.
County attorney's
and also
office.
possibly we anticipate filing our own motion about the pretrial publicity order that has a little bit different take on it. That should be filed in plenty of time for us to argue that on the 16th as well. I think we have set aside the 30th, and that might be the one we want to save to argue our anticipated motion that's coming about keeping cameras out of the courtroom.
Oh,
And
shit.
we will, I imagine the media will, depending on the court's ruling today, will want to weigh in on that one as well. And that would give them enough time.
Oh,
So that would be
God.
January 30th.
Let's Karenify the whole
Before I go
thing.
to the other parties, the January 30th date, there was some complications. And so we have to find another date.
Okay.
And so I just wanted to let all parties know before we lock in our schedules.
What?
What dates do we have available for a 4-hour setting?
I don't know.
It's okay. My problem.
lot of attention and
Counsel, I appreciate you
priority
giving me that
by the
roadmap that
defense
helps plan, so.
on
and it allows the
talking
other
and
parties to
viewing.
take
Yeah,
into
no shit.
consideration dates and filings as well.
Dude, just stand up and say I did it.
Because they
So as
want to
staff
put
is
him to
doing that,
death.
They are looking for hearing
Zero
dates. One of
chance
the
he pleads
complications
guilty
is, as a judge,
without a
I
deal.
have 1,409
Yeah, no shit.
cases as of last Friday. And so
But if
trying
they
to
have
find
enough
a
evidence,
spot
it don't matter.
is tricky. And I'm grateful for my staff who work so hard to manage that calendar. So that is part of the reason for the delay.
I gotta back it up here. I missed what the judge said there.
Him to
doing
death.
that. They are looking for hearing
Zero
dates. One of
chance
the
he pleads
complications
guilty
is, as a judge,
without a
I
deal.
have 1,409 cases as of last Friday.
1,410 cases this judge
is
has.
tricky, and I'm grateful for my staff who work so
Good
hard
God.
to manage that calendar. So that is
How many freaking criminals are in the U.S. just in Utah alone in just this county? 1,409 cases. Holy hell. This place is truly my name. Hell in a handbasket. It's gone. 1,410 cases this judge has. Just this judge probably does, I don't know, one county? I doubt he does. Well, it might be a state judge, so that could be the whole state. But 1,410 cases he has before the end of January. That is unbelievable.
is part of the reason for the delay, and we're trying to find a date because this is an important case, as is all of those cases. They matter to me.
Your Honor, while we're waiting, can I, if I might just make one.
Well, let's stop the lawyer gobbly-gook with all this yippity, 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 Karen, yippity, 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 and you might be able to go through cases. Let the guy stand up, give the evidence, done. Oh,
Point
heck.
that might make things smoother as we go forward with the seal filings.
Don't seal them. How about that?
Just to Ms. Nestor's point, Mr. Novak earlier mentioned something about a redacted motion to disqualify. And I don't know if that is something that they're planning to file, but I was just going to say sometimes, what we heard earlier about that particular incident is probably not something that we care that much about in terms of what they would redact. And so instead of opposing the motion to classify.
Oh, we know what they redacted. Lance Twiggs.
I don't know if this is the plan already in this case or whether
His new
that's
address.
what they were planning to do. But if they file a redacted version that, just takes out the stuff they care about rather than.
Because listen, you don't think he's called his ex-boyfriend already in his new place and is on the phone with him every day in jail? Oh yeah, he is. Guaranteed.
Closing the whole thing, then we don't have to say anything and probably avoids, fighting over unsealing that document. So I just wanted to say that. I'm happy to confer with counsel if you'd rather us do that.
We'll
if
chat
you don't
about
wanna
this
do
and
it
what
if
the
I were
status
forward,
is.
but
No, I appreciate that input. I'll hear from both parties, and then we'll get to the date.
Your Honor, I do anticipate going through and seeing what we can redact and working with the state on that as well and with media counsel. So.
All right.
And we agree that filing a redacted version is a good way to go. We can work together on that. As far as the January 16th hearing, the state will do everything it can to respond to these motions as timely as we can, as expeditiously as we can. I just want to note that January 16th
Just give a time limit.
hearing was set with the expectation. The previous expectation was that defense counsel was going to get us these motions before Thanksgiving. And we just got the motion to disqualify last night.
Oh
So
boy.
we'll do everything we can to respond to those as expeditiously as we can and hopefully keep that date, but I'm not guaranteeing that we'll make that date.
All right. I appreciate the heads up. Going to
Just put a
stand
time limit.
on dates do we have available for in lieu of the 30th?
Can't find some gobbly-gook loophole within the last 10 minutes.
February 3rd, morning or afternoon setting?
Your fine.
That works for Mr. Robinson, Your Honor.
All right, thank you.
Is that his dad?
And,
up
morning
there?
or afternoon setting?
Who's that?
Either works for us, Your Honor.
Who's that?
As well as for the state, we're available on the 3rd.
The afternoon would be better because it may be that it reduces travel time.
It could be
All
Shabbat.
right, well, it is always nice when all parties agree. So we have February 3rd at 1 p.m. It is anticipated.
Well, they're not doing nothing else.
And Ms. Nestor, is Mr. Robinson planning on appearing?
Yes, Your Honor.
All right, thank you.
So all these people have no schedule at all. They're only working on this case. They're only working on this case. The press don't give a crap. It's only the judge who has 1,410 things to do before then. Duh! And put a bloody time limit on when you're allowed to send out notices of, I have no more info. I have more info. 5 minutes before you walk into courthouse. These are all lawyer games. Gobbly-gook and lawyer games. Put a time limit. Be done with it.
All right, that concludes that.
Yeah, so this concludes the whole thing. They did absolutely nothing except for yippity Karen, yippity Karen. And try to set rules. Which they should have already done. But the only good information we got out of this so far was that the press guy gave it away that they're trying to disqualify Mr. Tyler's phone calls to his furry homo.
That particular issue about future dates, and I appreciate counsel working with me on that. We have December 29th at 10 a.m. for the court ruling on these two issues, and that will be via WebEx. And then February 3rd, January 16th, I believe that is at 1 o'clock. Is that correct? All right, that's in person as well with, I believe, defense has indicated Mr. Robinson will be present as well. And finally, February 3rd at 1 p.m. and also indicating that Mr. Robinson will be present. And in regards to the final issue, the ruling on the state's motion to clarify court's pretrial and trial publicity order. This is the order of the court. The court issued a protection order regarding pretrial and trial publicity in this case. The order prohibits attorneys who are associated with the prosecution and defense of this case from intentionally, knowingly, or recklessly permitting a witness, investigator, consultant, staff member, or other member of the prosecution or defense team to make extrajudicial statements, which, if made by the lawyer, would violate Rule 3.6. To that end, lawyers participating in an investigation or litigation of this case shall inform all witnesses, investigators, consultants, staff members, or other members of the prosecution or defense teams about the prohibitions contained in this order. The state moves to amend or clarify the court's use of the word witness as used in the publicity order because it is vague, ambiguous, or overbroad. The state asserts that there are over 3,000 lay witnesses of the alleged homicide.
Oh
The
boy.
state does not know if it must inform each potential witness or each potential and possible witness of the prohibitions in order, or whether the order applies only to witnesses who are members of the attorney's teams, such as investigators or experts. Due to the potential confusion, this court grants the state's motion and offers the following clarification. The word witness, as used in this order, applies to all witnesses who are part of the prosecution and defense teams. This includes any witness, including lay witnesses, whom the prosecution or defense has a good faith belief will be called to testify at a hearing or trial. The court also clarifies that the publicity order as written regulates the behavior of attorneys who are associated with the defense team or the Utah County Attorney's Office. It requires the attorneys to abide by Rule 3.6 and in order to deter non-attorneys from making prejudicial statements, requires the attorneys to inform witnesses about the prohibitions in the publicity order. Informing witnesses about the prohibitions in the publicity order is a necessary step. It is one moment as I regain my place as I read.
I'm stuck.
Informing witnesses about the prohibitions in the publicity order is a necessary step toward not intentionally, knowingly, or recklessly permitting witnesses from making prejudicial statements. The publicity order does not regulate the behavior of any person who is not an attorney associated with this case. And this order will be signed today by myself and made public. Counsel, is there anything further that we need to address today?
Thanks, Your Honor. Yes, just the matter of having Mrs. Erica Kirk designated as the victim representative in this case. She has filed through her counsel a request to be designated as the victim representative. And we would like the court to formally acknowledge that request and formally designate her as the victim representative. And I guess along those lines, I wanted to make clear as well, I think this court stated earlier that there was an alleged victim in this case. And I know that there is case law talking about being careful about how we refer to victims and alleged victims.
Oh, so they're going to try to say you tried to shoot somebody else and hit Charlie instead? That's very interesting.
But in this case, that case law makes clear that those cautions don't apply with the same degree, where it's clear that we have a victim who was killed in this case. We don't have an alleged victim. We have an alleged perpetrator, but we do know that we have a victim in this case.
Yeah.
Thank you, Mr. Ballard. I'll hear from the parties.
Your Honor, on behalf of Mr. Robinson, we certainly think it's appropriate for Mrs. Kirk to be designated as the victim representative, if that is the desire of the state, just so there can be no doubt that she's afforded all of the rights assured to her under our state statutes, and we have no objection to that.
Thank you. Thank you to all parties. This court will recognize Ms. Erica Kirk as the designated victim representative in this case. Thank you. Counsel, I believe that concludes our matters for the day.
One
Or
more
maybe
matter,
not.
Judge.
I hope so. Oh, no.
I can take the podium, Judge.
Yes.
Here comes the press guy again. Oh, wait.
I
No.
want to just give the court an update with respect to discovery. We've done that at previous
Thank you. I
hearings.
appreciate that.
The state has received approximately 13,900 files from law enforcement. In
This guy looks like a cop.
Approximately 300 of those we believe are duplicates. We have since provided to counsel, as of I believe this morning, 7,951 of those files. For the court's information, we had reached close to 100% had been disseminated as of last week, but we received quite a large batch.
Close
over
to
the last few
100.
days, so we were working on that. We still have a full-time paralegal that's dedicated to reviewing that.
Well, this guy is definitely a cop.
Stamping it and sending it out to counsel. Of course, there are necessary redactions that are being made along the way. Our next real hearing in this case, second matter, our next real hearing in this case is not scheduled till January 16th. We understand the court's caseload. We understand the difficulty of finding dates for a preliminary hearing. And we would like to make a request that the court calendar a preliminary hearing in this case.
All right. In regards to, and I appreciate the heads up and acknowledging the busy calendar of not only the court, but all of you. First of all, how many days does the state anticipate, which helps us in our calendaring efforts?
$1 billion
Given that it's a
question.
probable cause standard, and all
20.
the inferences go in favor of the state is asking for 3 days. We believe
3. It's going to be
there's
20.
evidence required to meet that standard, and that would also allow the defense to cross-examine witnesses and
There's no way in hell. They always under-exaggerate this.
Mr. Gernander, turning to defense, what are your thoughts?
Your Honor, we were not aware that he was going to make that request today. We do have one more member of our team that's not present that we would need to consult with. I don't know when he's talking about, but I don't see how we can set it until all the discovery has been received. And also, we do need to deal with the disqualification motion.
Oh God, here we go again. Jesus Christ. And I guarantee you that guy that just came up there was the state police legal rep. I'll bet millions on that one. And this girl, this Karen here girl, call her a girl. She ain't no girl. Oompa Loompa Karen here says, look man, I gotta disqualify Lance Twiggs from getting any sort of guilt on his neck.
Just in case. So it doesn't seem like a good idea to set it before we have the disqualification hearing. We were only talking about a month from.
We gotta keep the Trantifa out of this case. That's what we like to disqualify. The Trantifa. The tranny furry Tifa, dark web section. We gotta keep that out of this case. It's just this guy.
From now, I think that should probably be resolved before we set any dates. But I am concerned about setting a date when we still don't have all the discovery materials. We have significant discovery materials that have not been received yet, that we know are out there and coming and important.
Yeah, 7,000.
We have to, have time to review it all and absorb it all. And I am going to be involved in another trial that is not over until the end of March. So that's going to take away my ability to work and process through discovery and communicate with our team. So it seems to me that with the understanding of what Mr. Gernander is trying to accomplish, that maybe we come to the hearing on the 16th with an idea about, we can have some conversations with Mr. McBride and also with the paralegal that's dealing with all the discovery and see realistically when we think we're actually going to have the vast majority of the discovery materials to us and how long it's going to take us to review it all. So maybe we could just come prepared in about a month to try to accomplish that.
Or make a phone call, for Christ's sake.
Just 2 points, Judge. Sometimes I feel like we as practitioners sometimes lose sight of the purpose of a preliminary hearing. It is a probable cause determination. The primary purpose, according to case law, is to ferret out improvident prosecutions. So again, it's a probable cause standard. We are working as hard as we can, being very diligent with respect to collecting and disseminating discovery. Rule 16, subsection 2, speaks to the timing of mandatory disclosures. And it is our duty, it's a continuing duty. So as far as complete discovery being provided, in a case like this, complete discovery is going to be ongoing until probably trial. There are times when things become available during trial that are discovered.
All right, these people just keep on yapping.
It says here, it says the prosecutor's disclosures must be made as soon as practicable.
I will pause and
following
be
the
back.
following the filing of an information, except that a prosecutor must disclose.
All right, let's finish this off.
Was all evidence that the prosecutor relied upon to file the information within 5 days after the day on which the prosecutor receives a request for discovery from the defendant. That's been accomplished. It then says, in every case, all material or information listed under paragraph A1 that is presently and reasonably available to the prosecutor must be disclosed before the preliminary hearing. So we are in the process of that, collecting it as quickly as possible, making any necessary redactions, and moving it to the defense as quickly as possible. But complete discovery is not required before a preliminary hearing. We have to provide it as quickly as possible. We have that duty and we continue to do that. So we think we can schedule a preliminary hearing and work towards that. I'm aware of Ms. Nestor's schedule. I know she's going to be in trial, I think, in February and March. And I'm probably overestimating the availability of the court's calendar, but the hope would be sometime in April to schedule a preliminary hearing.
All right.
I'll submit it.
Thank you.
Your Honor, can I just clarify one thing? I mean, the county attorney has made a decision, very public decision, to announce their intent to seek death the day that there was an arrest, which means that that obligation to provide us with the probable cause for everything they relied upon to charge applies now to their intent to seek death. And we're no
So we got to keep him alive as long as possible. So April doesn't work. We got to do it next year or 2047.
nowhere near getting that material. So that was their decision to release that. Normally that decision is not made until 30 days after a preliminary hearing. They made it in advance, and now they've got an obligation to tell me their aggravation and what they've relied on to make this a death penalty case. And we have not received that. So I'm waiting, but I'm just laying that out there for now.
Thank you. I appreciate the arguments from all sides.
Even if he gets the death penalty, let's look at the last guy who got the death penalty and see when he's going to be gone. There's probably a 12-year waiting list. So it really affects nothing but 12 years of taxpayer money. And if they prove beyond a doubt that the bullet matches and they have him firing the gun and it went off and, you know, everything's cool. I mean, why can't they do it this summer? 4th of July, 250th anniversary. Put the guy in front of a, you know, firing squad.
Do not find there is any prejudice in setting a date for a preliminary hearing. It is not set in stone, and it certainly can be moved. I recognize that the parties have a lot of obligations, but I also recognize the importance of this case moving forward. And if nothing more than this is a goal for the preliminary hearing, if it needs to be changed, the court understands that. That is what happens a lot in the criminal calendars and criminal dockets. What is a date that we may have available for a 3-day setting for a preliminary hearing?
3 days. Well, they're all not doing anything else, so.
We'll talk about this once they're done. It's got some significance in terms of rights that she has.
Shut up.
Dates in June.
June.
All right. Counsel, I'll turn to you. Again, this is a goal. This is not a date that if we can't meet, there's any prejudice that will be attached to a party. In regards to May 18th, how does that tentatively look for counsel?
Perfect.
May or June?
May 18th is the first date, I believe.
Oh, I want to go on vacation to Israel.
19th and 21st, just to give you the full range.
The state can make those days work, Your Honor.
Of course they can. They got nothing else to do. He can make them because they're only working on his case. What arguments do we have there, Karen? Okay, Shlomo. I don't know. I guess so. I don't really have anything on the go except some bagels.
Your Honor, we have availability the May 18th with the understanding and the appreciation that if it's not feasible for us to get done when we need to get done prior to that, we would ask to push it back. But we don't have conflicts at this time.
Of course you don't.
All right, thank you. So May 18th, May 19th, and May 21st. And it will be in person. And do we anticipate, if that date moves forward, Mr. Robinson being in attendance?
Absolutely.
All right, thank you. I just want to put that on the record as well.
Well, unless he gets
I
Epstein.
don't want to be presumptive, but is there anything else?
Now they got the Epstein date down. Beautiful.
All right. Counsel, thank you again for your hard work today. And I wish you all, Mr. Robinson, a good afternoon. Court is in recess.
Thank you, Your Honor. Thank you.
All right.
And they wisely cut the stream as soon as court went out of session this time. Guys, what is with this cameraman and the risky panning? He literally just told you. Literally just told you. We got an order here. You got to be careful. You got to comply with it to the letter. And like the first thing he does is pan over to the defense table where they're reading their papers. And we're looking at their papers.
Yeah.
And he keeps doing this panning when you're in this you're in this orientation where you zoom out wide and the screen at the state's table is pointing directly at you. You just got super lucky they didn't have anything on that stream. Guys, the media is going to blow this. I'm going to call it right now. The media is going to blow this. Literally just got
Well, they're
warned.
trying to. Dum-dum.
Still couldn't figure out how to stay between the lines. They're going to blow it for all of us. So just be prepared for that, because I think that's going to happen. Well, let's
No yoit.
let's go ahead and start.
Probably got a G
with the
cameraman.
recap of what
Doesn't
happened
understand
today.
what's even being said.
Because we got here 4.5 hours ago, and they spent about 3 hours in a closed session talking about redactions and their closure hearing. So that, I gotta say, I mean, he said, oh, it was necessary. He made his comments when he came back into court that it was necessary to have this detailed and intensive conversation about everything. But I gotta say, that seems like a lot of overkill to me. I don't know why this took 3 hours to talk about roughly, like, I don't know, six or seven redactions or so, maybe. It's just a little wild, but it did. So we entertained ourselves in the meantime, talked about some other stuff going on. When we finally got into session, the first thing we dealt with was a violation of the decorum order regarding the transmission of this proceeding. The defense presented on it. Under the rules of judicial administration, the court has the authority to terminate media coverage at any point in time, with or without notice, based on findings of violation. In this particular case, they argue that there were certain things that happened that were a violation that threatened Mr. Robinson's right to a fair trial. At one point, they argued his shackles were visible. They had, of course, an entire hearing about the potential prejudice of showing him shackled on camera. So that was a restriction to mitigate that. That apparently was not carried out. Also, possible audio from counsel table that was overheard, and then filming of the computers and materials at counsel's desk. I didn't see the shackles. I didn't hear the audio. I didn't see anything significant that was being shown at counsel table the first time, but I sure did after we came back.
Okay, Rambler, let's go.
Notice they're like practically pointing counsel's paper, like right at the camera, all zoomed in. So this is going to be an issue. So the defense wanted the judge to just yoink the cameras today, right now, off the bat.
Stupid.
State didn't really push back. They just said, hey, if we think the order was clear and if there was a violation, there definitely needs to be some consequences for it. So then we heard from the media lawyer, of course. First time we've heard this. We don't know. We haven't looked at the video. We haven't looked at any of it. We don't know what's actually been captured. But he did acknowledge
we got a G
there was
cameraman. We can't be doing that.
Inadvertent capture of the shackles because of how they're zooming. Does it become inadvertent? Is it like still inadvertent when you're still doing your risky panning, already knowing that you've captured stuff you're not allowed to be filming, and you keep doing it? Are they going to come back again the
How long
second
is she going to
time
talk about this
and
camera?
argue, oh, when we were blasting whatever this note was that the defense attorney was reading all over the screen.
Okay, move on, moving on, moving on. She's going to talk 5 minutes about that.
Get copies of these proposed sealed documents on a quote attorney eyes only basis, which is a thing that happens sometimes, like federal discovery protective orders, very common to include provisions that certain things are attorney eyes only. Certain types of cases of the
Like what?
The type, I'm sure you can use your imaginations and
No, we
figure
can't.
that out.
Tell us.
Are real common
twigs.
to have things like that.
And the
So
rest of the
that was their
boyfriends.
proposal. You know, one way to maybe make.
What else did she got to say?
I mean, it could even be something as potentially remote as like the DA donated to the governor of Utah, and then the governor of Utah had this press conference and made statements that are prejudicial to Tyler Robinson. It could just be something like that, but it's going to be in the nature of that kind of issue. You know, a disqualifying conflict that because it implicates the elected guy and everybody else in that office answers to him. So there's kind of an imputed, problem there. They have the incentive to keep him happy so they can keep their jobs. The entire office would need to be disqualified. These types of motions do happen, not unheard of, sometimes win. And so if they win, what would happen? Potentially bring in a special prosecutor, potentially,
Yeah, okay. Next.
language that you use to describe people and things. And is somebody a victim or an alleged victim? It's really appropriate to refer to somebody as an alleged victim when there is a question about whether a crime has even occurred. But that is not this case. Charlie Kirk is clearly a victim. His family is clearly a victim of exactly what crime.
Okay.
If everybody isn't ready, then we'll move it. 5 months down the road, guys. That's our pace in the court. That's our pace. The news cycle is just not not in the same universe.
Okay, we don't need to hear from this lady anymore. Okay, so it's looking like they're going to stall and never be able to get together, but nobody's doing anything else. I mean, obviously the state's only working on this case, and they have their own lawyers, and they'll hire other ones. What we want to know was not told today. What we want to know, what evidence there is. For example, what he's pleading. None of that. This is just administrative gobbly-gook and yada 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 Karen crap and lawyer speak. That's what it was. But the only, I would say, A+ thing that we got out of it was that press lawyer who said they're trying to block how many phone calls he's making out of the jail to his hiding furry boyfriend and anybody else who may be possible or is on a list that we don't want the press to know about, because they'll go hunt them down like the FBI didn't. So they're already hiding stuff. So, it is what it is. It's just terrible that the legal system has come down to this crap, where you can't read the papers that this camera is zooming in. I mean, you'd have to zoom in like 1,000,000 times. I mean, can you read my shirt like it is right now? Nope. I gotta move. I gotta get up. Then you can read it. And you still have to pause the video, probably, unless I hold it exactly correctly for a moment. I mean, I'm looking at the screen. Hang on. Let me see if I can actually read it with the screen zoomed to the max. We know they are lying. They know they're lying. They know that we know they're lying. We know that they know that we know they are lying. And still, they continue to lie. Put in the comments who said that. It's a quote. Anyway, so we didn't really find out much except for the fact that they're hiding his phone calls and his communications behind bars, and they don't want to show his shackles on TV. So that's about it. That's all the comments I have. This was pretty much useless. Peace out.